Thank you for joining us today for this professional development program looking at managing your professional liability. I'm Andrea Salmon and I'll be facilitating the webinar today, and our presenter is Libby Brooks. Thank you so much, Libby, for being with us today. Libby is a Senior Associate and Head of Maurice Blackburn's New South Wales and ACT Medical Negligence Department. Libby is a New South Wales Law Society accredited specialist in personal injury law, particularly in the area of medical negligence. And Libby has a passion for social justice and fairness, and we do thank her very much for sharing her time with us today.
Thanks, Andrea.
I'm going to push a couple of buttons so that Libby can take over control. And then we're going to listen to what she has to share with us.
Thanks very much, Andrea. So I'm just going to share my screen and start the slideshow. So thanks very much. As Andrea said, I'm a specialist in medical law. And so what that means is that I look at medical records for most of my days. I'm involved in various cases for patients where there has been a medical error that has resulted in personal injury, or where there's been a coronial inquest in relation to what has happened in the course of medical treatment. So what I want to talk to you about today, and please, it should be interactive, so if at any point you have a question, please type it in, and then Andrea will ask me at an appropriate time and I'll do my best to answer it. I'm going to be talking to you generally about what medical negligence is, why medical records are so important for you in your professional life, how we look at medical records and how they can be used in a medical negligence trial, or even sometimes other legal proceedings like family law or coronial inquests. Privacy and medical records. We have been seeing with the development of technology and e-records that there are new issues arising, and I'm going to give you some tips on how to keep good electronic records and what to do if a patient texts you or sends you an email, which is seemingly a lot more common these days. So my background is I've been practicing in medical negligence law for over 10 years, and I'm currently representing one of the families, or one of the children who was injured in the Bankstown gas case. So they're the types of cases that I look at. I'm proud to work at Maurice Blackburn because I really enjoy working in a social justice firm that tries to help patients and their families or other injured people obtain answers and compensation. We have lots of different areas. We do employment law, class actions. We did the BRCA breast gene case, which you might have heard about. We do dust diseases litigation for people exposed to asbestos. Superannuation to help people who have an illness and are unable to work, such as people with multiple sclerosis, access superannuation and total and permanent disability insurance, and we do personal injury law. So what is medical negligence? We in New South Wales and ACT, where I practice, we have up to 100 inquiries in relation to things that have gone wrong with patients every month. Out of those, we have to work out if there is a medical negligence claim, and usually we only investigate maybe 4 out of the 100 cases that we have inquiries about. And I'll go through why that is as we progress. But the first thing that we do is look at medical records. And so that's why this presentation, hopefully you can take something away from it in relation to your dealings with patients, and give yourselves a bit of protection so that if one day you are involved and you have to talk to a lawyer about what's happened with a patient, you have really good records to confirm what you say happened or didn't happen. Hopefully that never happens, but if you do have to talk to me or another lawyer at some time in relation to medical negligence, then hopefully I can give you some tips today about how best to protect yourself. So medical negligence is an interesting area of law. It actually is not very common. Things like the Bankstown gas case are a rarity, where that little girl was given carbon dioxide instead of oxygen. But the legal definition of negligence is an injury or death caused through an act or omission of a healthcare professional. And that act or omission needs to be inconsistent with competent professional practice expected at the time in Australia, and the act or omission needs to have caused or materially contributed to the injury. So what does all that technical legal talk mean? If you are, as I know some of you are, an occupational therapist or a physiotherapist, or another health professional, and you are somebody comes to you and says that they think that you have breached your duty of care as a physiotherapist, I may look at the records and think that you did breach your duty of care, but my opinion in that sense doesn't count. We would need to obtain an expert opinion from a physiotherapist to say that the care that was provided by you was below the reasonable standard of care expected of a physiotherapist practicing in Australia at the time. Then we need to do the most difficult thing in medical negligence, in a medical negligence case, and that is work out causation. So most people who are interacting with the healthcare system have an injury or illness that they need treatment for. So we have to work out, did the alleged breach of duty of care cause or materially contribute to their injury? I recently had a case for a man who had melanoma, and he'd been to a skin clinic. He'd had a mole removed, and it had been sent off to a pathologist who reported that there was no cancer cells within that pathology result. However, about 18 months later, he developed a large lump on the side of his neck, and he went to a dermatologist and ultimately was diagnosed with stage 4 melanoma. And the hospital where he was diagnosed asked for those slides to be re-examined because they thought that the primary was the lesion that was removed. And in having those slides or that pathology re-examined, they found that in fact there were melanoma cells 18 months earlier. And so we obtained an opinion to say that there was a breach of duty of care from that pathologist who re-examined those slides. But we then had to prove that an 18-month delay in diagnosis would have materially changed his outcome, because the fact that he had melanoma is nobody's fault, but we had to speak to an oncologist or several oncologists to determine whether or not, if he had been diagnosed 18 months earlier, he could have had a wider excision of that lesion, chemotherapy and or radiotherapy, and he would have survived. And we were able to get that evidence. So sometimes we can obtain supportive reports from a medical practitioner in the area to say that there was a breach of duty of care, but sometimes we are unable to prove that even with earlier diagnosis or treatment, it would have made a material difference to the outcome. So that's why medical negligence is different to, say, other personal injury claims like a motor vehicle accident, where if somebody has a crash and they lose their leg, we know that it was the fault of the other driver, for example, if there was no alcohol or speeding involved. And we can work out, well, all the damages that that person claims, or all the costs of the prosthesis and treatment and operations were related to that accident. Whereas in medical negligence, we have to work out, well, what would the normal course of the injury or illness have been. And so that's why when we're looking at these matters, we, as I said before, we may get up to 100 inquiries a month. Out of those, we will open maybe 5 or 4 in a month. Out of those 4, let's say, we will look very carefully at medical records to determine whether there was a breach and whether earlier diagnosis or treatment, with a different diagnosis and treatment, would have materially caused that person to avoid their injuries. So we look at volumes and volumes of records all the time. And as I said, out of those 4, we may close 2 of those matters after looking at records. So medical records are really important. Not only, well, they're mainly important for continuity of care, and I'll talk to you about a case where medical records were looked at very carefully from the Supreme Court of New South Wales. But they are able to assist you to not only manage your patient, or if you go to a home to see whether or not something has happened before, what treatment they've had, and to enable you to give them the best care that they need. Obviously, that's the most important part of keeping good medical records. But also, they are used by lawyers, and it is important for you to have good records. If we think that there is a good case, we are going off initially what a client tells us, or a patient, and obviously they have a certain version in their mind about what happened. And so you may see, I don't know how many patients you'd see every week. It could be a lot. And if somebody comes to you several years later asking you what happened with that patient, if you don't have a record to assist you to jog your memory, then it can be quite difficult. Generally, if a judge or a coroner is looking at a case, the best evidence they look to is a medical record. So I've spoken to you about some case examples. So we see all sorts of different cases, and I've certainly done cases in relation to all of those. I've done a case where the wrong kidney was taken out from a little boy who was 18 months old, and that meant that he had no working kidneys, and so he had to be on dialysis, and his father had to donate his kidney to that boy. That was obviously an intraoperative error. Medication errors, where people have died when there has been incorrect medications charted, or otherwise people have misinterpreted handwritten records on transfer from one hospital to another. Failure to refer for further investigations, and I'll talk to you about a case that I ran in that regard. Delayed diagnosis, failure to follow up test results, or wrong clinical decision under pressure. So, as I've said to you, when the court or the law is looking at what is reasonable, it is the standard of someone professing to have that skill. So we're not expecting a GP to diagnose a brain tumour. That would be the area of a neurosurgeon to do. But the law says that even if you are a physiotherapist with 1 day's experience, you are considered to have the same experience or level of skill required as, say, someone who has 20 years experience. So the standard's not reduced if someone is inexperienced. And the court looks at expert opinions, firstly, from other doctors, and medical negligence obviously is a difficult area because we have to get expert opinions from, say, a GP to say another GP was had breached their duty of care. We look at protocols, so what protocols are in place, what requirements are there to document signs and symptoms in a hospital, for example, policies, statutory obligations, and then we look at case law. So in looking at liability, we're looking at who is responsible. And so in the course of your employment, there will be someone who is insuring you as a healthcare professional. And you will also have guidelines and practices and procedures that you have to adhere to under the various boards. So what I do is medical law or negligence, but we also assist people in New South Wales and across Australia in our other departments to make a complaint to the Healthcare Complaints Commission if we think that the care was so unreasonable that the board should be involved. And recommendations can be made to the medical board or the podiatry board or other various boards to have restrictions imposed. So many years ago, some of you might remember the butcher of Bega, the obstetrician down in the Bega region. We had several of those cases where that was criminal negligence in a sense. And we certainly encourage people, if we think that the care is so negligent, to make a complaint to the Healthcare Complaints Commission so that restrictions can be put in place and there can be a record of people's complaints. There's often questions I get, because I do these talks quite regularly, who, you know, as a nurse or a physio working in a hospital, who is responsible for the actions within that hospital. And generally speaking, in a public hospital or if you're employed by a local health district, the local health district is responsible for all your acts and emissions, or their insurer. If you are in a private hospital, if you are employed by that private hospital, then they will be responsible for your acts or emissions. But if you are an independent contractor, then you would need to have your own insurance. So as I said, when we're looking at all these inquiries that we get, the first thing we do is take a really detailed statement from the patient. But as I said, a lot of the time, patients or people, when something bad has happened, they have a certain version of what has happened in their mind. And sometimes when we get the medical records, or in 50% of cases, we'll look at that and we will say, no, look, we just don't think we're going to be able to prove negligence, or that any breach by a healthcare professional has caused an injury, and we close their claim. That's not to say that they might not then make a complaint to the Healthcare Complaints Commission in New South Wales, or the coroner if there's been a death, or then disciplinary proceedings might flow on from there. So good medical records help us as well, because we don't want to be telling people that they have a case if the medical records don't support that. Generally, a judge or a court or a coroner will accept a healthcare professional, especially where there's a good record, because, as I said, if something bad happens, and it may not necessarily be something that you've done, it might be that a patient dies, or is involved in some sort of family law issue, and those records are looked at, you don't want to be in a position where you're asked, what does that document, why didn't you record that, or what were their signs and symptoms? Even insofar as your personal health and safety, if you're going out to see someone and there is a family member there, that can be quite confronting or aggravated, or the patient themselves, then it is very important for you to document as close to the event what you saw and what happened, because then if you're ever called upon, it could be, as I said, a month later, a year later, if you can go back to that record and say, well, this is a record of what happened, then it's very good for you. I don't think you need to do reams and reams of documentation, and I know from speaking to nurses and professional people working in the healthcare system how onerous it is these days, having to really record absolutely everything, and the paperwork is excessive. But really, it's just a matter for your professional protection that you record what you see or what you did at the time to protect yourself. And I'll go through some examples of that. So
someone's asked a question about whether it's different for NGOs, or not-for-profits, in regard to the employee or employer held accountable.
I would say that the NGO would have, or not-for-profit organisation would have insurance, and that insurance would cover them. So the law says if you're working, like even if you're a volunteer, or even if you stop by the side of the road to help someone as a good Samaritan, the law still says that you have to act reasonably. So it would be the case, I would say, that the organisation who is employing you would have professional indemnity insurance.
Thank you.
Okay, so obviously there is a defence to negligence, and that is a professional is not negligent if they acted in a manner that at the time the service was provided was widely accepted in Australia as being competent professional practice, unless the court finds that opinion to be irrational. So again, lots of very complicated words, but what it means is if, for example, and I will go into this shortly, goodness, I've gone too far, but I'll go back. If, for example, you're a general practitioner, and I ran a case of Thompson and Hasbrook, where a patient who was living in a rural area was going to a general practitioner with a complaint of pain in her neck radiating down her arm. The general practitioner saw her on several occasions over a year period, and she said she was getting worse to the point that she couldn't even walk into the general practitioner's surgery by the end of that year. She was on a walking stick. She had lost her son in the Bali bombings, and so she was also depressed. And it seems that the general practitioner was putting her signs and symptoms or her complaints of pain down to depression. But he was increasing her pain medication. Now, we obtained expert opinions from 3 general practitioners to say that the care provided to her was below the standard expected of a rural general practitioner. And the other side, so the insurer for the general practitioner, obtained 2 general practitioner experts to say that the care was fine. And of course, the general practitioner who treated her was saying that it was fine. She went on and had to have spinal surgery because her spinal cord was trapped between her 2 bones in her vertebra, and she nearly became a quadriplegic because of this delay in diagnosis of this impingement of the spinal cord. And she was in fact having pain radiating down her arm, but the general practitioner said, oh no, it's just depression, you're sad. And he was upping her antidepressant medication, but he was also increasing very strong painkillers for osteopain. This matter did not resolve at a mediation where most matters resolve, and that's why you don't hear a lot about medical negligence cases, because most of them resolve out of court. But this matter went to trial before a judge, and the judge was looking at records. I can't remember the year, but I think it was about 2005 or 6 when she was going to see the general practitioner. And the trial took place in 2010, so a long time after the medical records were recorded. How the law works now is that you have all the general practitioners sitting at the bar table at the same time. So we had our 3 general practitioners saying that there was a breach of duty of care, and the other side had their 2 general practitioners, and the judge asked them all questions at the same time about what the reasonable practice was at the time and whether he should have referred her on to a neurologist at that time, whether she did have neurological signs and symptoms progressively over the period of time. So a judge in that case was faced with, well, who do I accept? We have 3 reasonable general practitioners saying that the care was not reasonable, and then we have 2 reasonable general practitioners for the defendant saying that the care was reasonable. So how did the judge work out whether or not there was negligence there? Well, he asked them all lots of questions, and he referred to Murtagh, which is a textbook which general practitioners use, and ultimately decided that although there were 2 general practitioners supporting him, the general practitioner, that in fact this general practitioner had breached his duty of care, because the textbooks say that if you are a general practitioner and there is pain in the neck radiating down the arm, that is a neurological sign and it should be further investigated. So the medical in that case, the plaintiff or the patient had to give evidence in trial, and she got up there and she was absolutely terrible because her memory had faded. She didn't have any documentation. She was just going on what she remembered, and obviously to her what had happened was terrible, but she was not believed by the judge, because she couldn't remember certain days or certain consultations, and there were several consultations where she'd been to see this GP. So we were really worried, thinking, oh my goodness, this is terrible, you know, the judge is not going to accept her. Then the general practitioner got on the stand, and he was just as bad. He couldn't remember, because obviously he'd seen all these patients, and he was saying, no, it was not neurological, but it all came down to one record, which is this record here. So it was 2003 when she was recording signs and symptoms. So it was 7 years later that they're talking about a date in 2003. And it was pain in the neck radiating down the right arm. And the judge and the general practitioners, the experts for both sides, really couldn't get away from the fact that the GP had recorded that one side. And even the GP conceded that that was a neurological sign that should have had further investigation. So we ultimately won that case, but when you're called to give evidence about something that has happened many years ago, if you don't have a record to refresh your memory, it's very difficult. And generally, a court will accept a professional who has recorded something as that being the best evidence, because it's the most contemporaneous, it's the closest to the event, and memory or time or hindsight or bias, self-bias has not kicked in. No questions? So this is an interesting case, and it goes to who's responsible for what I do during the course of my employment. And I think it's a really interesting case because it looks at a public hospital, a private hospital versus a doctor. And this is a situation that I can see is going to happen more and more often in the future. Not the negligence so much, but people trying to say that it's not our responsibility as an employer, it's actually the doctor's responsibility, it's not the nurse's responsibility. So this is a very sad case. It was run in the Supreme Court of New South Wales in 2016. And again, it related to something that happened in 2008. So if you're thinking about that, if you're asked, 10 years after the fact or 8 years after the fact, what happened 8 years ago, and you'll have to give evidence in a trial, it can be very difficult. And I know I'm obviously a professional as well, and I see lots of clients and I speak to lots of people, but I'm very good at keeping file notes because I've had a situation myself where I had to get up in court and be cross-examined about some advice that I'd given a client. I think that was 10 years earlier, and it was lucky that I had one letter which showed that what I said was in fact correct. But so I know what it's like as a professional. But in this case, which was very sad, Mrs. S was a 61-year-old woman, and she was admitted to Newcastle Private Hospital for an elective vaginal hysterectomy performed by private obstetrician Dr. Brown, gynecologist and obstetrician. So he was practicing, or he had visiting rights to Newcastle Private Hospital, where the surgery occurred. And Mrs. S had signed a waiver saying that anything that happens in the hospital is not the hospital's responsibility. She relinquishes them of all liability. However, unfortunately, during the surgery, a loop of searcher material was inadvertently looped around her bowel. And then over a period of 5 days, she was admitted on the 1st of December 2008. But by day 4, she had passed away. And that was because of a blockage, which was caused by this loop of suture, which was inadvertently tied around the bowel. Over that period of 4 days, she deteriorated, her oxygen levels went down, and she ultimately suffered from a cardiac arrest and died. So this case, the Dr. Brown admitted to the plaintiff, and it was a case brought by the husband and two daughters as a result of Mrs. S's death. Dr. Brown said, yes, I did the wrong thing. I made an error, and if I had not made that error, or if the signs and symptoms of her deterioration had been picked up over that 4-day course, we could have gone back in and we could have repaired or given a colostomy bag, and it would have repaired it, and Mrs. S would have survived. He paid compensation to the family, and I don't know what that was, because this case wasn't about that. But the hospital refused to contribute to payment of those damages. And the hospital, who was representing the private nurses, said, we were not responsible for Mrs. S's care after the surgery. It was only the responsibility of Dr. Brown, because she was a private patient in a private hospital, and he should have picked up the deterioration over the course of those 4 days. So this case was basically the hospital versus the private doctor. And so it was an insurance company versus another insurance company. But Dr. Brown was saying, yes, I was responsible, but I was only responsible for a portion of it, and the hospital was also responsible, because by its nurses, they had a duty to look after her, record in the medical records, along the clinical pathway document, which was a policy that the hospital had, the signs and symptoms after an elective hysterectomy. So the judge found, and the Dr. Brown admitted that he did owe a duty of care and that he breached that. The judge said in the course of this judgment that it was common ground that during the operation, a loop of suture material was inadvertently looped around Mrs. S's bowel. Tragically, that error was not discovered until after her death. The result was that the blockage was not identified or addressed, infection set in, she repeatedly vomited fecal material, she inhaled some of that material with resulting pneumonia, her electrolyte balance became distorted, her oxygen levels deteriorated, and she suffered a fatal cardiac arrest. Very sad. So Dr. Brown said that a doctor has to rely on the nurses to alert him or them to a deterioration of a patient's condition. And the nurses had a duty to record vital signs and advise the doctor of a deterioration in the patient's health. So specifically, as I said, it was alleged that the records were so poor that when Dr. Brown came in on his daily rounds, he was not alerted to the fact that she was deteriorating. And clearly she was deteriorating so badly that she suffered sepsis. So there would have been signs and symptoms if they'd been recorded. And the records, again, very important. The hourly graphic charts were not filled in adequately, and post-operative observations were not recorded. And there was no clinical pathway document completed. So the hospital said, yes, its hospital staff, for who we are responsible, failed to record observations in the clinical pathway, and they failed to record further observations in the 4 hourly graphical charts. But they said that they still were not responsible for her death, that the ultimate responsibility lay with the private surgeon who'd done the operation. Dr. Brown said he was 75% responsible, and the hospital said that they were only 5%. If they were responsible at all, they were only 5% responsible, so they would only contribute 5% of the damages. So this whole case, which went on for days and had lots of experts, was all about who contributed the most. The court found that there is a positive duty on nurses to record because those medical records are essential for continuity of care. And if those records had been done, it would have been noted that she was deteriorating, and she would have avoided her death. And the court found that the hospital was 20% liable. So ultimately, Dr. Brown won that case, and it would have been a lot of money and a lot of heartache about who was responsible. So that case is important about for two reasons. One, records are so important for a patient's care, mainly because I'm sure it would have been very hard for that family to hear that if proper records were kept, their mother and wife would have survived. And secondly, it's important because it shows that you can be an employee of a hospital or an organisation, but that organisation can come to you and ask you about your records, and if you haven't followed the policy or procedures that are in place, I'm sure that those nurses involved, it would not have been very enjoyable for them to have to speak to the lawyers on several occasions about why they didn't record those signs and symptoms. Any questions? Just a time check.
Libby?
Yeah.
There's been a question, thanking you for your examples so far, but wondering if you have any examples of successful suing of physios or OTs.
No, you'll be happy to know. So we look at OTs and physios all the time, physio records, but I've never ever had a case against a physio or an OT. But the records are still important because I have had a case against a podiatrist, a chiropractor, those sorts of allied health areas. But we do read physio records a lot, and they are very important because, for example, in that Thompson and Hasbrook case, Mrs. Thompson was seeing a physiotherapist at the same time as she was seeing the GP. So it was corroborative evidence for us to say that she was complaining of neck pain because the doctor was trying to say, oh, well, she was just depressed. So we do subpoena physio and OT records all the time, and we work with OTs and get expert reports and physios all the time, particularly in cases where there's been a catastrophic injury for a child, because we need to work out what's the cost of care, and if somebody has the surgery, what type of physio they're going to need and what's the cost of that. So we do review physio and occupational therapy records all the time, but I've never sued one. I have had some inquiries about physios, but I've never done a claim where someone says that a physio told them to wait there when they shouldn't have, when there was a fracture, that kind of thing. But usually that goes back to a failure by, say, radiologists to properly report on a fracture. But I've never had any inquiries about OTs. So, so that's a good thing for you. But that's not to say that you might not be, like, we do use those records as corroborative evidence, and it is important for us because the physio wasn't called in that Thompson and Hasbrook case, but very well could have been, and we had to get a transcript of their records because they were quite hard to read. And we did speak to that physio in depth, and they did give us a statement. So they can be important for other reasons.
Absolutely, thank you. I'm also going to take the liberty of giving you a 15-minute warning because we've only got 15 minutes to go.
So I'm not going to go through this example because I just want to go to technology, because I think that's really important as being a physio or an occupational therapist, and boundaries between patients and healthcare professionals, because you know, we see a lot more when we're investigating cases. They might say to me, oh, I called my doctor, I asked for advice, I texted the midwife and she told me to stay at home, or you know, I'm sure there just seems to be more of a blurring between the lines of patient healthcare professional relationships now, I see, or family members contacting you, you know, out of hours. And so I think it's important just to run through a few little tips there. Obviously, the person who creates a medical record as a physio or an OT or a case manager, you own those records. There can be things within those records that are sensitive to patients. There's confidentiality that surrounds that, and obviously you can't talk to, if a certain family member asks you about someone that you're treating, you cannot really talk to them without the consent of your patient. So, like there's been cases where we have requested records and a patient is asking us for those records, but there are certain things within that record, might be a wife or a husband, within that record that are sensitive, and we have to be really careful about whether or not we disclose private information to other family members. So, as I said, when we're looking and investigating cases, we look at text messages or phone call records from a patient, and they should be saved. Essentially, well, firstly, I would say try not to communicate with a patient electronically if you can. I know that that's really difficult, but if you do, it does form part of the medical record, and you should make sure that you save that communication, whether it be a photo or a text message, into the medical records. So this is, I always think about it like I work part-time, and I'm obviously connected all the time to my computer, but if somebody from my work, one of the junior lawyers, calls me and asks me something, and I'm distracted, or they send me a message, what should I do about this? I try not to make decisions when I'm not at work, or give advice to clients and other lawyers about legal issues because you're distracted. And I just find that it can come back to haunt you. So this text message was sent from a woman to a surgeon, and he's engaging, he's giving advice, and you know, it really is a blur of that patient professional relationship. And this case nearly went to trial. It resolved shortly before trial, but those text messages would have been adduced as part of the medical record, but they weren't saved as part of the medical record. So I guess my advice is, if you do communicate with patients electronically, you have to somehow save them, because they will have them, and it's or it's for your benefit that you have them too. Social media, obviously we have lots of complaints from people which aren't negligent in the sense that, you know, something bad has happened, but we've had complaints, oh, the doctors were on social media, on Facebook, I could see them on Facebook, and my child, you know, pulled a tube out while the child was in ICU and nobody was watching. So those sorts of things obviously are very hard for patients who will remember if they saw you on social media and something bad happened. So it can be a distraction, and we just get lots of complaints, not necessarily negligent, but complaints about people not really focusing on taking instructions or taking advice from people, or if they come out and ask a nurse to come in and they're on social media, it really makes people upset. The other thing, obviously, is not to post anything about a patient on social media, because it comes out in the media, and it's obviously, you know, embarrassing. So it's just something to be aware of. That obviously, photos or things that are happening that might hit the media are a no-no. Emails, again, big way that people are communicating with doctors, and this is a good example, I think, of a record where an email was sent by the patient to a doctor, and the doctor converted that into his medical records. So that's a really good thing to do. If you're getting emails as patients, or you're going to their homes and then they email you something about a referral, or they're complaining about headaches, and you've recommended that they go and see their GP to get a referral, then, you know, any communication you have with the patient should be included in your medical record for your own professional liability protection. So, in summary, it's a lot of information, but that's just a little bit about how we use medical records, why they're important. As I said at the beginning, the reason that they are so important is that they provide a historical account of the care given. They indicate what was known at what time and by whom. They are generally contemporaneous and therefore carry more weight legally. We use them to identify potential witnesses. Like I said, in relation to that case that I ran, we found the physio, we asked for a transcript, and they're regularly subpoenaed by all sorts of different lawyers. And it's just good to have clear, concise, as contemporaneous as possible records. So if you're going to someone's home and there's an altercation, or you witness family violence or something, it is important that you record what you see, and do it as close to as possible the event as you can, because we do go through records with a fine-tooth comb, and the last thing you want is to be sitting in a courtroom cross-examined about a record, you know, and as I said, it doesn't necessarily mean that it's a case against you, but it might be something that you recorded that becomes crucial in a case where something bad has happened, and it's always best to have a good record, or as good a record as you possibly can. So yeah, so there's just one, that's a really, really bad record, and people have gone back and written, and that child ended up having brain damage, and so it was in contention. But rather than, obviously it was during the birth, and the midwives, it was a medical emergency, so they obviously have to concentrate on getting the baby born. But they knew that something was wrong, and they knew that there was going to be an inquiry about that particular birth. And so rather than write a retrospective note a few days later, or 5 hours later before they went off shift, they went back and wrote within the original record. And in that case, we ended up getting a handwriting expert and looking at the colour of the pens, and it was very, very bad for that midwife, because they had gone back and written inside the records. Those black parts are de-identified, so I've crossed out names, but they did go back in and change times and things like that. So that's just another thing. If you forget to do something and you're thinking about it, then you can always go back, even if it's a week later, or a month later even, and just record it somewhere in your records. So general principles: make the entry at the time of event, or indicating the entry when the event occurred. So if you're doing it a week later, say, I went to this person's house to do an assessment and witness a fall risk or something like that. I went to this person's house last week and the time, if you can. Record what you see, not what you think you see. So that's important too, to try not to be too judgmental. Like, for example, alcohol, like the person smelt of alcohol plus, rather than the person was drunk. And document, if you do refer someone on, document that you did refer them on to someone, if you think that there might be something else happening that's not just what you're there treating them for, something that might be able to assist them with their medical care. Any questions?
Thank you, Libby. We'll give people a couple of minutes to type in their questions. I'll just take that. But thank you for that. Just in the time that it takes to actually type, I'll just go through a couple of bits about us, and that's just a filler so that people have a chance to type away. I would just remind everyone that's online of the services that MSL can do to support any clients that you might be working with MS. It's a bit of a blatant plug, really. But for your professional practice, we would let you know about some resources that are available on our website. Nothing, of course, to do with the legal side, that you would go to Libby for any of that. But in terms of your practice around managing MS and MS symptoms, there's a range of books available through our website, free to download, on managing, as I said, various aspects of multiple sclerosis. We also have some ebooks that are available to you guys who have registered for these programs, and that's the details of how to access those. Some are more client-oriented, but some are very much health professional-oriented, and we would like to make that service available to you because you have participated in our professional development program. And if you're really keen, you can purchase other webcasts of PD programs through our website. So let me check if people have been able to pop in some questions in that time. And there is one. Libby, do you advise that therapists explain their clinical reasoning, why they have chosen a particular treatment or intervention versus another one?
To the patients or
Or
within,
maybe
within the record?
maybe the notes.
In the notes? No, I don't think they do, but you would have to record the signs and symptoms in the records. So, you know, or you could say, weighed up, referring them to a pain management specialist versus trying functional exercises for another week, or conservative management, recommended conservative management for a month, and then refer to a pain management specialist after that. So it doesn't have to be your reasons why if you have put in a management plan and the symptoms are recorded. So I hope that makes sense. I don't think you need to put a whole explanation in.
Yeah, we tend to use the SOAP acronym. So subjective observations, objective observations, the action that you're going to take,
yes, and the plan.
actually the assessment and the plan.
Yes, that's right. Yeah, yeah.
Thank you. Now, there don't seem to be any more questions. There's a thank you that's come in, so that's lovely. Thank you to everyone that's been online. I hope you found it beneficial and are going away with some things to think about differently. I know I certainly am. I've written myself a note, particularly around how the text messages should form part of the client's record. So yeah. I'll be giving that some thought as well, how to do that, get some lessons on that. So thank you very much, Libby, for your time.
Thanks, Sandra.
Thank you everyone for being online. If you wouldn't mind just staying online for a minute to complete a survey that will pop up as soon as I finish the webinar, that would be very helpful to us as well. Thank you all very much, and I look forward to seeing you at another program.
Bye.
Bye-bye.